And welcome back, everybody, to the Law and Crime Trial Network. In just minutes, we are going to take you inside the Nicholas Godejohn case. Closing arguments are expected to begin, where we are finally going to hear the culmination of this case from both sides. You can see the attorneys in the courtroom, the judge is there. I see the defendant in the corner there. So things probably are going to start any minute. But in the meantime, I want to bring in my guest for this afternoon, LaDawn Jones. She is with me via Skype. And Judge Brandon Birmingham. He also joins me from Texas via Skype. Judge, so nice to see you today. Tell me what your thoughts are as we go into these closings. What does, you know what, we don't really need to worry what the prosecution needs to do, because I think they have the easy job in this case. Tell me what the defense needs to do to convince those jurors he's not guilty of first-degree murder.
Well, the defense is going to, they're the ones that called the star witness, Gypsy, right? And they're going to give the jurors the highlights of that. She claimed responsibility for the murder in the sense that this was her idea. After all, this is her motive. That is her motive for the killing. Her mother obviously mistreated her for so long. And so it was not his motive, it was her motive. And the way that she lured him to do things, convinced him to do things. This wouldn't have happened unless it was for her. Those are some of the themes that they're going to be hitting on during their closing argument, all to get the jurors to buy off that this was not a premeditated or a deliberated or an act made with deliberation.
Okay, so let me ask you something, LaDawn. Don't you think that's going to be a pretty tough hill to climb to convince the jurors that this wasn't premeditated? I mean, we both know that they had planned this. Yeah, it was Gypsy's idea, but there's no doubt that Nicholas wasn't behind some of the planning.
That's absolutely right. I think it's going to be almost impossible. And for me, I think the key thing that shows premeditation is which portions of the crime were actually committed. Something about the fact that that Nicholas wanted to rape the mother, right? Mm-hmm. And Gypsy was able to convince him not to, let you know that this was a plan and we conducted this part of the plan and not the other part of the plan. Premeditation is going to be almost impossible not to, for a jury not to believe that this was premeditated.
And Judge, I don't know how much you've been able to dig into some of the details of the case, but I got to tell you, in terms of the scale of cases that we've covered, this is one of the crazier ones just because of the details. The abuse this woman Gypsy faced are really unfathomable. When we're talking about Gypsy, because she did take the stand, as you mentioned, in the defense's case, do you think she got the right outcome here? I mean, because many people will say, well, she was the mastermind here. Why did she get away with second degree and only 10 years behind bars?
Well, I think you could probably look far and wide and not see a more documented, accepted case of abuse and really mind-warping than what Dee Dee did to Gypsy. I mean, convincing somebody that they are sick, the way that she was, all those hospital stays, she had a feeding tube, she was starved, she was totally isolated. And I know that's hard to imagine, but if ever there was a case, I mean, the saying is there are victims and there are complainants. That's the saying, at least around here. And certainly one of the things that the defense is going to want to do in this trial, they've got to be careful. They don't want to necessarily vilify Gypsy. They're going to want to vilify Dee Dee. And so it's going to be an interesting way to see how they're going to play that.
Well, I think in terms of the evil in this case, I think everybody would agree on both sides potentially that the victim, sadly, was really the evil and perpetuated a lot of what happened. But with that said, it does not excuse either of their behaviors. Clearly, just because you're abused, and horribly so, many people are abused and they don't go out and kill their mother because of that. If you're just joining us, it looks like in the courtroom they have gathered the judges there. I think they're going through some instructions that they may give to the jurors. So there's a little bit of back and forth about that. So I don't want any of our viewers to think they're going to miss a minute, because as soon as those closings begin, we will take you there. In the meantime, I want to continue our discussion specifically about Gypsy Blanchard, the co-defendant in this case's testimony. And I've talked to LaDawn throughout the last hour about it, but let me talk to the judge about it. What did you make of how she came off on the stand?
She was very matter of fact. She was very, I thought, credible. She didn't search for answers. The statements that she made were corroborated by some of the other evidence that we've already heard in this trial. So she had the ring of truth pretty much to everything that she said. It was an interesting dynamic. I don't know if anybody else agrees with me or not, but I'm looking at a clip of her testifying right now. She had that hair, and it was sort of over the left part of her eye, and I swear it's like she didn't want to see Nicholas, and she didn't want to look at him. But I thought that her testimony came across as very credible, very believable. She, I think, gave the defense some points, but I tell you what, the cross-examination by the prosecutor, bringing things home to a very digestible level for the jurors. After all, it was Nicholas who secured the murder weapon. He chose the method of killing, which was with that knife. He picked it out, for goodness sakes. He's the one the prosecutor asked, I thought, a really good question. It wasn't Gypsy who decided to stab Dee Dee 17 times. Gypsy wasn't even in the room. It was him. He had opportunities all throughout the course of that year-long decision-making process to back out, and he didn't. And I thought one of the other poignant things was the three methods to get rid or extricate Gypsy from that relationship, one of which was pregnancy, one of which was to try to get the mama to like him, and that didn't work. So the next one was murder. So they were thinking about this. They were planning for this. They even got stories together. He's the one that selected the murder weapon. He was not honest with the police. All of that's going to go to really, really hurt Nicholas and his argument that this was not a premeditated killing.
Okay, so it looks like, Judge, that we have the attorneys in court. The jurors are not present, and that they're arguing, the defense is arguing about jury instructions, specifically trying to say this was sudden passion. Let's listen. Now the prosecutors are responding to that. Okay, so they were just going over some jury instructions, and the jurors can consider first-degree murder, second-degree, and involuntary manslaughter. The defense had wanted voluntary manslaughter as well, but that requires an impulse, a heat of passion, and the judge felt like this case didn't warrant that. Judge Birmingham, who is also here with us, he's in Texas, do you think that was a wise decision by the judge here?
I think that the judge is going to make the call that he feels like is supported by the evidence. And, you know, we've been talking about this. It's kind of like, you know, on the one hand, the defense has this motive that the reason for the killing was one that they will hope the jurors will feel like was justified in some level. The problem is that it's not anywhere near what they would consider to be a sudden passion. Sudden passion means something that happened and that the killing immediately happened after it. And so that's what the ruling the judge made. Okay,
so I don't want us to miss, and LaDawn's also on standby here, I don't want us to miss a minute of these closings. We have to take a quick break, but on the other side, we'll take you back inside that courtroom in Springfield, Missouri. Stay with us.
Murder.
Okay, so you're hearing there the judge gives some jury instructions to the jurors before we get into closing arguments. Different states do it different ways, but sometimes, you know, these jury instructions can go on for quite a while. And Judge Birmingham, in your experience, because you're a trial judge, how hard is it for some of these jurors who are not attorneys for the most part to kind of understand some of the intricacies in the law? And in this case, it does matter, because not only are they deciding first degree, they are also considering second degree murder and involuntary manslaughter.
The jury charges, we try to make them as easy to understand as possible. Unfortunately, the laws were written by lawyers, as near as I can tell, because they're never quite so clear. But really, that's where the art of advocacy comes in. And I think probably what you're going to see in this case, as you see in courtrooms all across the country, is that the lawyers will pick and choose those legal footholds that are most important to their particular case, and they will give the jurors what that means. You might hear them quote it, but they'll tell you what it means. You might hear them refer to instruction number 6 or 8 or 5 and tell them that these facts that they heard prove that 5 should be answered a certain way, you know, things like that. That's probably what you're going to hear. We always give the jury charges, copies of the jury charges to the jurors, and I think that's what the judge is going to do in this case too.
And LaDawn, let's get into a little bit of the nitty-gritty here. As we mentioned, you know, the jurors are considering first-degree murder, but they're also considering second-degree and involuntary manslaughter. As you look at this case yourself, is it possible that the fact pattern could fall into any of those lesser-included charges?
You know, clearly, this was a case where the jury is going to be looking at, was the intent planned before they went in? Did this person know what they were doing? I do think that the judge was right in allowing the jury to be instructed and to include the lesser included. But whether or not there has been enough evidence at this point, considering the heinousness of the crime, I think we talked a lot about this earlier, and his mental capacity, which doesn't always go to actually reduce the level of the crime that is charged. So it is possible, but we don't know in this case. We'll find out when the jury comes back.
Okay, and the crux of the defense's argument was Nicholas Godejohn had autism and was not able to form the requisite intent for a premeditated murder. They also put Gypsy on the stand, his co-defendant, who took a plea deal to 10 years, and she talked about, and this was yesterday, she talked about how it was all her idea and her plot. Let's take a listen to some of that testimony. Okay, so we're just listening to some cross-examination of Gypsy Blanchard, who is the co-defendant in this case. You know, during the direct, she talked about how she thought of this plan. She wanted to kill her mother, that she got her boyfriend on board with this. But what, Judge Birmingham, do you think the defense, or excuse me, the prosecutor was trying to do during the cross-examination?
Well, he is setting up his argument that he's about to make to these jurors, that when they talk about premeditation, this cool reflection for however brief a period of time, obviously, things like the taser, things like the duct tape, you don't need to duct tape somebody. I mean, if you're bringing an instrumentality of crime and or death into the crime scene, you know what you're doing. Procuring the knife, as we talked about before, getting your story straight, telling her what to say, making sure that we have our story for the police right means that you know there's something that the police are going to be asking you about. So this all goes right square to that jury instruction.
And I think, LaDawn, he was also trying to show, you know, he was plotting too. He said, no, I'm going to wear the gloves.
Absolutely. So I'm not sure what was behind Gypsy trying to take responsibility, if she did that on her own accord or if she was led to do it by someone, responsibility on behalf of Nicholas. But the prosecutor was laying out very clearly that this was something that together they both planned. And again, as we mentioned earlier, this was an interdependence between the both of them. They both led each other down the path, but Nicholas himself made some of those final decisions in the final moments to commit this murder.
All right, this has been just a fascinating case that we're covering gavel to gavel. We have to take a quick break. We'll be back in just a few minutes. Stay with us. Welcome back, and we're going to take you right back to that courtroom in Springfield, Missouri, in the case against Nicholas Godejohn. He's facing first-degree murder charges for his involvement in killing his girlfriend's mother, Dee Dee Blanchard. Right now, the judge has just finished giving jury instructions. He's going over the verdict form, and we are expected in just a few minutes that we are going to hear closing arguments from both the prosecution and the defense. I've been joined for the last half hour or so by Judge Birmingham. Judge, what should we expect going into these closings? What does the prosecutor need to do in order to really secure that first-degree conviction here?
The usual playbook for a case like this is the prosecutors are going to open the argument. They have the burden of proof, so they're going to have one prosecutor is going to open, and that tends to be the one that will go over the sort of technical, legal arguments that they're going to make. They'll probably walk the jurors through the jury charge. We want you to answer this question like this. This is the verdict form that you need to fill out. This is what premeditation means. This is the difference between first and second degree. This is why you should vote for first degree. Put out facts like that. and it's very factual and very legal. It's probably going to be pretty sterile, not terribly emotional. Then you'll have the defense go, and they'll put on their defense, which is a diminished capacity defense, this idea that autism plus an overbearing and manipulative co-defendant is the reason why we're here, in hopes of getting a lesser included offense. And then you'll have the lead prosecutor on the case will wind things up and rebut everything that the defense has said.
Talk about that rebuttal, though, for the lay audience and why prosecutors get that opportunity, because some might say, wait, that's unfair. Why do prosecutors get 2 chances in closings?
The rule is that way, that they get to open and close because they have the burden of proof. They're the ones that have to prove the charge beyond a reasonable doubt. It's their charge. They're the ones that bring it. They get to go first in jury selection. They get to go first with presenting the evidence, and they also get to go first in the arguments. So that's why it is. The prosecutors will open, the defense will have an opportunity to go, and then the state will have that rebuttal argument to have the final say-so of why they should, the jurors should believe they carried their burden of proof.
All right, so like we mentioned, the judge has gone through jury instructions, they went over the verdict form, and as soon as, not much happening in the courtroom, so you're not missing anything, don't worry. So as soon as they do begin closings, we'll take you there. But in the meantime, I think it's pretty important to hear a little bit more about the defense's case. We're hearing from a doctor that was put on by the defense that was talking about the autism that Nicholas Godejohn had. Take a listen. All right, so you're just hearing a little bit from Dr. Franks talking about autism, and he says that Nicholas Godejohn did have that. He was on the spectrum, diagnosed him with level 2. We're taking you in the courtroom right now in Springfield, Missouri, where closings are about to start any minute. We did cut out a little bit early from that soundbite because we did not want you to miss a beat of these closings. So it looks like there the prosecutor is. They are positioning the microphone to make sure everyone can hear. He's going up to address the jurors. Again, these are the closing arguments in the case against Nicholas Godejohn. Let's see if we can listen in and see if we can hear anything yet. Okay, it looks like the closings haven't started just yet. They have to do some logistical maneuvers, set up the microphone. Judge Birmingham's on the line with me as we look and see what's going on. You can see that is the defendant right there sitting next to his defense attorney. He has a very stern, solemn face on right now. Is that something that jurors... Oh, sorry. Okay, I was going to ask you a question, Judge, but it looks like they're beginning, so we'll get to that afterwards. Let's go to the closings. Okay, so you're listening to the prosecutor giving a pretty comprehensive closing argument in their case against Nicholas Godejohn. I'm joined by Judge Birmingham from Texas via Skype. He's been with me for the last hour or so. As we listen to these closings, I think the prosecutor is doing a pretty effective job giving those jurors what they need in order to determine that he did deliberate this murder. What do you make of the closing so far?
Well, jurors latch on to things that they've seen over and over in a trial. The repetition is key. We've seen those text messages. We saw them and referenced them in the opening statement. He showed some of those to Gypsy during her testimony as well. They show this. They all go to show this deliberation, this idea of cool reflection, especially the one standing outside the door, especially the one about procuring the gloves, about whether or not to wear the gloves, and especially the ones about picking the knife and picking the weapon. And he's doing an excellent job about reminding the jurors about those little details that all add up very, very persuasively, that this was not sudden passion, this was not a one-off impulsive decision. This was one that they had an extraordinary amount of planning and also an extraordinary amount of time for deliberation. I thought it was great when he talked about how he wanted to make sure he had the right address, and then away from Gypsy, he's Googling her address, making sure that he's got the money for the cab, all the way up to her front doorstep, and choosing what to wear to scare her a little bit more while he's stabbing Dee Dee to death.
And he's also hitting this autism defense head on as well in those closings.
Absolutely. The doctor, Dr. Franks, testified that yes, he is autistic and therefore more apt to be impulsive and a little bit more apt to be persuaded to do some act. But, you know, it's the facts and circumstances of the case. He very well, it's not disputed that he has that diagnosis. What is in dispute is how does that impact his ability to make decisions? And the prosecutor, Mr. Chapman, right now is making all kinds of very excellent arguments all along the way. These little nuggets, these little decisions he's making, what weapon to choose, how to get to the scene of the killing, what they're going to do after the killing, how this has stirred some sadistic desire in him after he's accomplished the killing. All of these things are being laid out in a very persuasive manner.
Judge Birmingham, thanks as always for joining us here on the Law and Crime Network. I know you have to run. We have to take a quick break, but we'll take you back to Missouri in that courtroom live for closings in just a few minutes. Stay with us.